state and the defence had a discussion about the contents of the report, and we both elected and decided that it's not necessary for the person who compiled the report to testify. So the state and the defence both admit the correctness of the contents of the factual allegations as set out in the report. Obviously, and some of those are merely opinions, and the state and the defence will address the opinions made in the report that we got. So the first one will be added in therefore as an exhibit. The court will please guide us regarding to what exhibit we will call that, Your Worship.
The defence confirms the receipt of the reports. I further confirm, Your Worship, the further address by my learned friend in as far as the reports are concerned as to how do we go about in dealing with them. We are fairly comfortable, Your Worship, in proceeding in that fashion, as it is the question.
As the court pleases, yes. The second report, Your Worship, is the one compiled by Ms. Patiswa Musa. She is present in court, but the situation is similar to the previous report. The state and the defence agrees that the contents of the reports can be submitted in as evidence.
That is correct. Yes, Your Worship.
Firstly, the pre-sentence report drafted by Ms. Patiswa to be marked as Exhibit S1. Court.
Yes, that is the question.
Thank you. The suitability report for correctional supervision drafted by, let me just find the name, Ms. Mashlanyana, will be marked as Exhibit S2 by consent of the defence agent.
As the court pleases.
Mr. Bakade, if you are ready, then you may proceed.
Your Worship, in mitigation and proceeding firstly with the personal circumstances of the accused. The accused, Your Worship, is 21 years of age. But I must mention, Your Worship, that at the time of this offence, when it was committed, the accused was 26 years of age. I can again, Your Worship, confirm that she is single. Not yet married. The accused, Your Worship, is currently a registered student at Walter Sisulu University. She has been enrolled on an honours degree in education in the current year, and she has already, Your Worship, obtained 2 qualifications with the same university. The accused is a single parent. She's a mother of 2 children, ages 13 and 10. Both children, Your Worship, they are very, very attached to the accused. And they share a very strong bond with their mother. Worship, until recently, these children were residing with the accused. However, Your Worship, these proceedings took its toll to the accused to a point that she could not cope. She suffered mentally and otherwise. Now the accused, the children, they are in the interim residing with their paternal grandmothers. Worship, the accused has been raised by her grandmother. And she refers to her grandmother as her mother and her pillar of strength. Worship, this has been widely covered again in the reports placed before you, which I will deal with them at a later stage. The accused, Worship, has never had a close relationship with her mother. Hence, Worship, she has always referred to her grandmother as her mother and her pillar of strength. Her parents, Worship, they divorced when she was only 5 years old. And since then, she grew under the arm of her grandmother. And Worship, in the recent month, her grandmother's health has taken a sharp about turn, and even currently she is not well. Hence, Worship, we did apologize for the late start to the court because the accused had to take care of her grandmother first before proceeding to court. Worship, I have submitted before you that the accused is currently registered for an honors degree, and already she has 2 qualifications under her name. But Worship, I must submit that it has not been easy. After passing matric, the accused could not proceed straight to university because there were no funds to take her to university. The accused, Worship, together with her brother and cousins, were solely depending on their grandmother's old age grant. Hence, it was difficult, Worship, to proceed to university. And I must mention, Worship, again, that the accused at home, she resides with the grandmother, her brother, and her cousins. All of them, Worship, they are currently unemployed. Hence, again, Worship, I would emphasize that it was not an easy journey for the accused growing up, and still, that is still even the case. Once again, Worship, if I may just take a glimpse to the report once again, where it is mentioned, Worship, that the accused is the hope. She's carrying the hope of her home, as she's the first person to have been taken or to have gone to university. From the brief background, Worship, given, it is quite clear, Worship, that the accused has emerged from a very poor background. And if I may, Worship, again submit before you and remind this court the evidence that was tendered before you when the own state witnesses, Worship, had attest to that indeed her background is not that rosy. Worship, the accused, having failed to get to tertiary after she passed matric, she went to look for a job whereby, worship, she took care of her family and then made little savings, worship, to take her through university. Indeed, worship, she managed to do just that. She was admitted at the University of Walter, at the Walter Sisulu University. Where she unfortunately, worship, encountered this incident. Looking at the accused, worship, her conduct, her attitude towards life. She is a go-getter, very committed person, to a greater extent, worship, a principled one, forgetting, worship, the hiccup that brought us here today. It has been submitted before you, worship, that the accused is a first offender. And apart from this case, worship, she does not have any pending cases. That as well, worship, shows her commitment to the rule of law. Worship, we do admit that the offense may be serious. However, worship, we should submit once again, worship, that the occurrence and the effects of this case, worship, sets it apart from other cases, your normal cases of theft. Evidence was tendered before you, worship, as to how this offense had taken place. One may say, worship, it was a poor judgment on the part of the accused. We, however, worship, submit to this honorable court that the court, worship, may take into account of all the surrounding circumstances leading to this offense being committed. It is quite clear, Your Worship, from the evidence tendered before you, that ordinarily the accused is a law-abiding citizen. It is quite clear, once again, Your Worship, taking from how this offense took place, it was just like a normal day in the life of the accused, sitting at her residence, and of course, worship, with an empty stomach, as per the evidence that was tendered here, worship, that at the time the credit was transferred, she could not even afford to buy a quarter of a brown bread. That is a gloomy picture, worship, that depicts exactly the life of the accused before this incident took place. Of course, worship, she regrets the events that unfolded after this error took place. I can submit, worship, without any fear of contradiction, that she has suffered quite drastically. We, however, you should carry our hopes and place them all before this honorable court. We know, Your Worship, the duty of this court is to dispense the justice. We are mindful, Worship, of the fact that indeed this court, Worship, will take the interests of the justice into a greater consideration, interest of the society, and the nature of the offense itself. However, Your Worship, looking at the evidence tendered before you, with our submissions, Worship, we submit, Worship, that may this honorable court take into account as well the interests of the accused. Worship, as per the proceedings, as our law is a fairly balanced law, Your Worship, in dispensing justice, it was appropriate, Worship, under these circumstances, that we source and obtain reports, Worship, which may assist this court, Worship, to come to a just and a reasonable sentence. I therefore, Your Worship, wish to proceed and refer this court to the two reports, Worship, that were received. And with your leave, Your Worship, if I may make references, Your Worship, to the probation officer's report, authored by one Ms. Patty Swavusa, and we must say, Your Worship, we acknowledge the work that was done by these officers, considering the turnaround, the short turnaround time, Your Worship, that were afforded to them. Your Worship, the accused was interviewed for quite some days, so that this court, Worship, can get the benefit of not just a report, but a well-founded and factual report. Your Worship, on page 4 of the report, the officer, Your Worship, sets out, Your Worship, as I have submitted to court, the background of the accused. Whereby, Your Worship, in paragraph 5.3, the officer submits as follows: the accused is described as a caring, responsible, and supportive person in the context of her family, who has taken the role of her parents. Who have taken the role of her parents in that she went to look for a job at an early age to care for her family. This is exactly, Worship, what we were trying to bring to the court's attention, that seemingly we are not dealing here with a career criminal, someone who rely on crime. This was just an unfortunate incident, Worship, that had occurred. The facts of the case, Worship, speaks exactly to our submissions. Further sources, Worship, they were consulted as well. And if I may refer you to paragraph 5.6 of the report, it is submitted, Worship, that various sources who were consulted during investigation portrayed the accused as a caring, supportive, cooperative, ambitious, sociable, vigilant, and a humble person. As I have indicated, Worship, this was a wild consultative process to a point that even her partner was interviewed. And these were his submissions. Her boyfriend also acknowledges the attributes reported regarding the accused. However, as an active, talkative, and a free person, he knows the accused to be. He notices some changes to the accused in that she is now withdrawn and reserved. Worship, you will recall that I have submitted the effect of this case to the accused. As much as the court, Worship, is still due to pass its sentence, however, the accused already, Worship, has suffered tremendously. Your Worship, the report goes as far as to, again on paragraph 6, to make submissions about the living conditions back home of the accused, which, Your Worship, they attest to what we have submitted already, that she indeed comes from very, very poor background, and she carries the hopes of her family. Your Worship, on financial circumstances, again the report confirms, Your Worship, indeed what we have submitted, that indeed the household of the accused solely depends on the old age grant of her grandmother, which is 1,890. Hence, Your Worship, we emphasize once again that the accused is carrying the hopes of her family. Yes, please, the court. Thank you, Your Worship. Your Worship, the officer went as far as to investigate, and also she has taken into account that the accused Your Worship, has a very close relationship with her children. She, however, Your Worship, cites that in the event, unfortunate event, that she may not be there for her children, of which, Your Worship, we know the effects of children growing without parents can be, which we submit, worship, that it will really be not in the interest of justice that when that event occurs, because even the officer, worship, the only provision that she can think of is that they can be accommodated somewhere, even away from the family. That, worship, under the circumstances may not be the best. Worship, I will not bother this court by repeating the qualifications as we have placed before you. Even the report, worship, carries such qualifications as I have placed before this court. Worship, the report as well highlights the road that she has traveled in trying to sustain her family. And to put emphasis, worship, on that, I wish to submit, worship, that it would appear that if the accused finally completes her studies, she will, without any doubt, worship, be supportive of her family, financially and otherwise. Can see, worship, as well, it is not your everyday, it is not an everyday occurrence that you would even, worship, an instance or a situation whereby even the clergy would, worship, make some submissions. And the report, worship, her priest, worship, was also interviewed, whereby, worship, he confirmed that indeed the accused is such a humble person. And what that translates to, worship, it means the accused, if she may be taken away, the society may lose. She touches, worship, people in so many ways. That has been confirmed by her priest. Worship, if I may refer to page 11 of the report. On page 9, worship, under criminal offences, whereby in 9.1.1 it was held as follows, worship. According to court records, the accused pleaded not guilty to the offence. However, during the interview, she said the court has addressed her about all the factors surrounding the charge of theft, and she understood and acknowledged the charges against her. The offence seemed to be not premeditated due to her reaction to the money transferred erroneously to her account. Once again, worship, this, if I may complete the next sentence, worship, the accused verbalizes remorse and guilty state of mind. Worship, our justice system, this is all that it places emphasis and look for. Are we dealing with someone who is remorseful? That is a determination. Worship, it's quite clear Is it someone who is remorseful or regrets what has taken place? And it is this court-worship. It is this court-worship that will afford the accused the second chance in life. Her future is bright, worship. But she only needs the springboard of this court to ascertain and to confirm her future. And once again, worship, from the report, it is highlighted that she utilized the voucher, the credit, to buy vouchers for other students. But most of all, worship, she utilized also the voucher to buy food and clothing for her children. And also, worship, the learning material of her children. Remember, worship, the accused family solely depends on her grandmother's old age income. She utilized, worship, that voucher, and also, worship, that's confirmed by the expenditure that was placed before you. Worship, but out of the report, of the issues raised by the report, which are utmost important, worship, without any doubt, but there's one, worship, that took the energy out of me. If I may refer this court, worship, to 9.2 of the report, impact of the offense on the victim. Worship, the court will recall that I have begged this honorable court that when it considers its sentence, it's common cause that it considers and put emphasis on the interests of the community and that of mostly the victims. The officer, worship, penned this report as follows under this paragraph. During investigation, I'm starting on line 3, worship. During investigation, Intelimali was consulted with regards to the impact of the offense on the organization. Through the official, the probation officer communicated with the CEO at Intelimali. The CEO at Intelimali said she is not available to comment until the finalization of the case. And it was explained, worship, the officer went as far as to say it was explained to Intelimali the purpose of this report. That the prescribed format of the report was explained to the Intelimali that it requires the detailed views of the victim and the professional opinion of the probation officer about the overall content of the report. Remember, your worship, this complaint was lodged, even though by Intelimali, but emanating from the NSFAS credit. And this was, and the officer, worship, was compelled to meet and interview NSFAS. And this is the submission, worship, from the NSFAS. The office on behalf of NSFAS confirmed that the organization has not suffered any financial loss due to this offense. when the incident came to light, NSFAS commissioned an internal audit review of its systems and controls and confirmed that no financial loss was suffered. Furthermore, investigations were also conducted by Walter Sisulu University and the Department of Higher Education and Training. It is the view of the officer that while the accused ought to have known better to not spend money she was not entitled to, that criminally charging the accused is unfortunate, and that it has an effect of destroying a young person's future when the system of the service provider should have prevented an erroneous transaction from having to be effected. The service provider could have pursued other means to recover the money from the accused once she completed her qualification and obtained gainful employment. Worship, the reason why I placed before you this paragraph, as I have submitted before you that the view and opinion of a victim is very important. Worship, in the years I have appeared in matters of this nature, I'm sure your worship, this court will agree with me that we always come across very angry victims who demand justice at all costs. However, your worship, this is a different picture that I've just placed before you. I can submit it before you, your worship, without fear of any contradiction, that it has never and it is not the intention of NSFAS and Intellimali that the accused may be sent to prison. It does not appear to be their wish, worship, that a young life, worship, with a promising future, looking at her enthusiasm, worship, to develop herself academically, can be sent to prison. Your worship, the report, worship, at the end has gone, worship, having considered all the circumstances, as it only serves, worship, as a recommendation to this honorable court. It has, worship, played around and looked around a suitable sentence, worship, which it may recommend to this honorable court. Your worship, it is their submission that the option of a direct imprisonment may not be an appropriate one under these circumstances. On the question of a fine, worship, currently it states that the accused has no source of income. Worship, it also recommends, worship, that in the event that indeed this court may consider the correctional supervision, it may so do so, considering the fact, worship, that the accused is not a danger in the society, and therefore she may remain within her community. And the last one, worship, the suspended sentence, which the officer, your worship, has taken time to investigate in the event that this court, worship, having looked at the circumstances of the accused, the case itself, the nature of the offense, what sentence, worship, again may it consider. On suspended sentence, worship, she submits as follows. Suspended sentence with conditions which can be determined by the court appears to be the most appropriate sentence for the accused. If the court imposes suspended sentence with conditions, the probation officer has consulted with Walter Sisulu University and Lingelihle Senior Secondary School for the accused to conduct community service as a non-custodial sentence under the supervision of the institution and the probation officer. And the period of community service and number of hours will be determined by the court. Worship, I wish to submit that we entirely agree with this recommendation. As I have submitted, worship, that the accused is a promising individual with a lot of potential. It will be unfortunate, worship, that such a talent may be lost in prison when other people, worship, within the community may benefit from her potential. Worship, the conclusion, the recommendation, in light of the above information regarding the social circumstances of the accused, the interest of the society, the nature of the offense, and also taking into consideration that this offense involves dishonesty, it is respectfully recommended that Sibongile Mane be considered for suspended sentence with conditions in terms of Section 297 of the Criminal Procedure Act 51 of 1977. Worship, we certainly, worship, agree with this recommendation, but worship, I must mention that indeed they serve only as recommendations to this court. But we submit, worship, that may this honorable court take into account, worship, the recommendations of this report, which were thoroughly investigated. Worship, I did not touch the part whereby they went as far as to interview the lecturers and the staff at Walter Sisulu University, who all agreed, worship, that the accused is such a promising individual with different attributes under her name, very committed, a born leader. Those were submissions, worship, from the Walter Sisulu University. That is why, worship, I did emphasize even from the beginning that we are not dealing, worship, with a criminal here in the true sense of the word criminal. Worship, the second report of the Correctional Supervision Report, that as well, worship, has followed suit and interviewed worship the family of the accused, her grandmother worship. They have worship gone through as well to look at the support system of the accused, which they have confirmed worship that indeed she has a very strong support system, including her partner worship, who stood by her through the thick and thin. Worship, the officer worship on page 5 of the report on D, paragraph D. During the interviews, nothing wrong like a bad behavior has been identified. She was so cooperative. As the result, no time was spent unnecessarily. She regrets what she did. Worship, in evaluation and assessment on page 6, right towards the end worship of paragraph 2, the officer worship held as follows: I have found the accused suitable candidate for correctional supervision under section 2761H. If the magistrate consider correctional supervision, the Department of Correctional Services is facing a challenge of overcrowding. The centers are overcrowded. Once again, worship, we wish to emphasize, worship, that looking at the accused, we humbly so submit, worship, that she is definitely not a candidate to be placed under direct imprisonment. It is matters of this nature, worship, that a second chance, worship, can be afforded to the accused, with a lesson, worship, that will not destroy the accused, but will serve as a deterrence and building the accused. That is why, worship, these recommendations have been set out, which, worship, clearly show that the community will benefit out of the accused. I understand, worship, the state has indicated that they will call for a harsher sentence. I so wish, worship, that they may look at all the surrounding factors about this matter, and their focus, worship, should shift when necessary and concede when necessary. This is one case, worship, that the state may not act as or like a program machine that if one is found guilty, we will call for a direct imprisonment. That is not a matter of that nature. That is certainly for. Are there any grounds, worship, that this court may have to consider or shift, worship, from the normal sentences imposed on the offense of this nature? I so submit, worship, that indeed, looking at the nature of this offense, worship, how it came about, how it was committed, and also, worship, reminding the court, worship, from the evidence that was tendered before you, where all the witnesses, worship, indeed confirmed before this court that it does not appear that the accused had planned before this incident took place. as much as worship we have acknowledged during the address and proceedings that indeed the accused regrets then what then unfolded thereafter. Which worship is so submit that may this court take into account that the accused worship owns what happened. She regrets what has then taken place. Are there any grounds worship that this court may shift in terms of imposing worship any minimum sentence? Worship, I so submit that looking at the age of the accused, there is a potential that indeed out of this offense she has learned something. And looking at her age, it will be a lost worship to other people who rely on the accused, and worship even the probation officer's report. She has alluded to the fact that after qualifying, the accused will then add or contribute to the fiscus. Are there any substantial and compelling circumstances, worship? Even though the legislature, worship, left it to the hands of the court to determine on case-by-case basis, worship, what may constitute such compelling circumstances. In SCA, worship, it was held State versus Malchus, worship, 2001, volume 2, essay 1, 222, SCA. That worship, the court to depart must satisfy itself that at least there are there's a weighty justification. Worship, I have alluded already on the nature and how this offense took place. That on its own, worship, will tell you that indeed pure mistake took place, and probably the misjudgment or lapse in judgment from the accused has brought now her before this honorable court. Worship, looking at the victims of the offense, they have not come across as people who, in fact, cannot afford the accused a second chance. As much as, worship, we do acknowledge there was a monetary loss, however, worship, it does not appear that the victims, worship, can simply want to condemn the accused to direct imprisonment. Worship, we have placed before you that the accused is family orientated. She has 2 children, worship, very attached to her. She shares a very strong bond with her children, worship. That without any doubt, worship, will destroy her children should she be taken away. Worship, the accused does not come across as a dangerous person, not at all. She is a very determined young person who wants to make something out of herself. Currently is doing her honors degree, of which, worship, once or if in the event, unfortunately, then that she may be sentenced to direct imprisonment, that all of that will be gone. The hopes of her family, worship, will be destroyed. And therefore, worship, in recommending an appropriate sentence, Your Worship, for you. We acknowledge the seriousness of the offense. We, however, Your Worship, plead with this honorable court that in taking into account the interests of the society and balancing all of that, Your Worship, may the court also, Your Worship, take into account and regard to the personal circumstances of the accused, who find herself, Your Worship, in this situation, that she never, ever, Your Worship, when she decided to change her life for the better by going to school, by furthering her education, so that at the end of the day, Your Worship, in as much as she will obtain education and qualification, but also to better her society and to better her family. We therefore, Your Worship, submit that the accused, Your Worship, is a candidate to be given a second chance in life, and there is only one institution at present, Your Worship, that can provide all of that to the accused. It is this honorable court. Having looked at all the circumstances, Your Worship, surrounding this case, we so submit humbly so that the accused, Your Worship, is a clear candidate to be afforded a second chance. And therefore, Your Worship, under these circumstances, a suspended sentence, Your Worship, will best suit the accused, as it is the court, Your Worship.
Rising partners, man.
in any of my submissions. Thank you. Your Worship, then, the first, I would like to, I have drafted heads of argument, so I would like to submit that to the court, consisting of a few type pages, 8 pages, and I have attached to the heads, I have made copies, just for ease of reference, of certain of the case law that the state will refer to, and I would like to therefore hand that in to the court. It will also make it easier for the court to follow my argument, and obviously it's not necessary to write everything down, because I will mostly concentrate on what appears in the heads. So I would like to then refer to page number 1, the aggravating factors that the state would like to highlight, and that is -BA. I would submit that it is an extremely serious offence has been committed, and the reasons therefore is, firstly, it is a matter of theft of public money that we are talking about. I had a discussion with my learned friend, and we basically agreed on a certain statement that was submitted by a representative of Intellimali, explaining the following regarding my submission that it is taxpayers' money that was stolen. It is explained that the taxpayer is supported, they support the National Student Financial Aid Scheme, as referred to in paragraph 2 of the preamble of the charge sheet. This financial aid scheme then transfers money over to certain universities, and the one was then the WSU, referred to in this matter, the Walter Sisulu University. Intellimali was the company, the complainant, because they were involved in the administration of the money, to disperse that money to different students, and to supply them with the credit cards and so on. Intellimali informs that immediately after they discovered that the money was stolen, they immediately refunded the Walter Sisulu University with a full amount, and that was in order that those students were prejudiced because of the theft. One can imagine what the effect would have been if the money was not refunded, and how serious this offence would have, what the effect of the seriousness of the offence would have been if the money was not paid over, and some students even had to stop, or the finance of those students had to be stopped. So the purpose of this money was all around to aid poor students, and the accused basically therefore stole and abused this money. The real complainants would have been the students. My submission is therefore that the interest of the communities in large is highly relevant under the circumstances, and one can understand that the public sees this offence also in a very serious light. Further aggravating, I'm referring to page 2 on the top, is the fact that the actual loss was never refunded or recovered, and it seems to me will probably never be. The next issue that I would like to highlight is the accused was entitled to an amount of only 1,400 rand per month. The state submits highly aggravating is the manner how the accused started to spend the money. The accused embarked on a lavish spending spree over a fairly lengthy period of that stretches over a 2.5-month period. Now, the details thereof was actually summarized in the preamble of the charge sheet, and I would like to refer refer the court to paragraphs 16 to 22 of the preamble, highlighting firstly how aggravating it was that the accused immediately, paragraph 17, immediately embarked on a lavish spending spree. From the 1st of June to 14 August, the accused spent a total of 818,469 rand 20 cents at 48 merchants in the Eastern Cape, stretching from Johannesburg even right up to Centurion. The prohibited items to the value of 286,108.70 cents were purchased. If the court just could pay attention to what was bought, it included alcohol, cigarettes, electrical appliances, bedding, airtime, gift cards, toys, microwaves. Paragraph 20 indicates that an amount of 178,923 rand was spent over the same period at Discount World in Fleet Street in East London. Paragraph 21 indicates that another amount of a total amount of 174,631 was spent over a period of few days at Checkers, Hyper in Centurion. Paragraph 22 indicates that the accused was provided every time when a purchase was done with a receipt, and the balance of the money was indicated to her specifically. She made the first purchase at just before 3 o'clock that afternoon, and my understanding of the evidence shows that she already on that first day checked the balance of how she was spending 12 times. So it's not a question that this was not done with a criminal intent. She was well aware, step by step, every time that every cent was spent. She even, paragraph 23 indicates that the accused actually renamed herself to Sigo Belly Money, showing the lavish intent that she had at the time. I refer then to my heads again. The state submits that the accused has been placed basically also. We must not forget that if you hand a credit card over to somebody, she is placed in a position of trust. She then takes the responsibility, she understands what the credit card rules are, and she operates because she was trusted with that credit card. And she completely abused this position of trust that she had. That is the state's submission. The facts also indicate that the accused had this credit card for quite some time before the offences happened, before the overpayment was made. So, the state submits that she was therefore well aware what the rules were relating to the rules regarding to credit card expenditures of this nature. And she just completely ignored them and abused them. She therefore ultimately abused the trust relationship that she had with the university. Also, the point number D, it is highly aggravating, Your Worship, in the sense that the accused then embarked on this lavish spending spree over a fairly lengthy period of time. The beginning of this crime could possibly start start with an indication that, but she could have come to her senses after the first day or having spoken to somebody. But no, after that, the accused continued for this whole time spending a vast amount of monies on luxury items, useless items that has got nothing to do with spending money or necessities for the family and so on. My solution that is an indication that it is highly aggravating under the circumstances. Bishop, furthermore, the offence of theft, what she did, States admits, was not on the spur of the moment kind of thing, although it was over a period of time, but it must have been properly planned as well and premeditated. Because every evening she was sitting enjoying what she did the first day, going on the next day, and she even started then planning to go to different areas and keep on spending, and so that quite possibly, I'm not sure whether that was the purpose for not being detected, but why do you visit Centurion? Why do you visit the July handicap? Why do you go to George, for instance, to go spend the money there? I'm not sure, but the minutes will indicate the reasons for that. My understanding is that according to what I would like to also do, let's now compare her evidence to a reasonable, as painted by my colleague. She was just a reasonable youngster student under the circumstances. Now let's compare the facts, whether she was indeed that. Firstly, she was not a youngster anymore because she was 27 years old at the time when she did this. She planned travel trips to various places over the country during the spending spree: Centurion, Queenstown, George, Durban. That is the intention of a criminal to operate like that. The accused purchased goods on cash. My understanding is that there was a place here in Fleet Street, East London, where she was even completely against the credit card rules. She was never allowed to use any cash. She decided, I'm going to cash amount and make cash purchases. So my submission is, it's highly aggravating that, furthermore, that most of the type of goods that were purchased were not necessities. And I would like to, I've already referred to paragraph 9 of the preamble of the charge in this regard. Then furthermore, another highly aggravating factor, we're not talking about small cash here. The amount is very high. A total amount of 818 rand, 469,000 rand and 20 cents was ultimately the financial loss. The effect of this loss, I made a simple calculation. If you divide this amount by the monthly allowance of other students that could have got 1,400 rand per month, if you divide the total amount, divide by 1,400 rand, and divide that further by 12, you get to a figure of 48 students could have benefited from this actual loss in that same year. So we're talking about the effect of this theft is not small fry in the bigger scheme of things. And also, highly aggravating is the fact that this spending spree did not stop because of the accused's own actions or omissions. My understanding of the facts were that the theft was stopped because Intel Mali discovered that it was a typo mistake and they subsequently blocked the account. So it's got nothing to do with the accused at that stage that came to a senses. And that, my submission is that is highly aggravating under circumstances. I refer in the attached documentation to us, to the case, the references are there in the bottom of page 3, state versus Piata. And the point, this matter, if the court will look at it's on page 31 of the attached documentation. But the bottom line, the point that the state would like to make is that the court ultimately found in that matter that although there was little likelihood that the accused who committed that type of offence, and I'm aware of the fact that, and it's not law that every case should be handled by its own matter, but I'm referring some case law just to be used as guidelines, as factors that the courts previously already took into account. Because in that instance, the court said, although there's little likelihood that the accused will repeat the offence, and her prospects for rehabilitation look good, but there were a number of aggravating factors. One of them was that there was nothing to suggest that the accused would have stopped stealing for being discovered or caught out. So, what I'm trying to say in Piata and probably other cases as well, the court sees this in a very serious light when somebody gets caught out and it was not through her own means that she stopped or came to her senses. Bishop, and then I would further like to differ from my colleague with reference to the so-called remorse that was shown by the accused. I submit ultimately, and I will refer to few, would like to.
Please, the gentleman and the lady, you are distracting me, although you are speaking softly. It's difficult to hear all the sheets and masks. Please stop. Thank you. Thank you. Continue.
Thank you, Bishop. Ultimately, the accused was facing the charges now after the credit card was blocked and the criminal trial was a criminal case was opened. She faced arrest, and now she was arrested. What did the accused do? She elected not to take the court into her confidence and pleaded guilty and showing obvious real remorse by doing that. My submission is, and understanding of the facts of this matter is, the accused instead decided to plead not guilty. She made only, as in Exhibit B, she made 6 admissions to the court, and then the trial pleaded, and then the trial proceeded, and a prolonged trial stretching over 3 years occurred until the accused was finally convicted. I know that is a right to plead not guilty and to contest the evidence of the state, but when there is reference made by true or real remorse, this is, my submission is, this is quite an important factor to take into consideration. My understanding further, and I would like to be corrected if I'm wrong in this, but my submission is that one of the arguments was that the accused was basically entitled to these monies because she would have been ultimately responsible anyway for the payback of that monies. If that is indeed so, I, from the state side, submit that it is highly unlikely that the accused could have believed that from the start. Because if it was a loan, no reasonable person under circumstances will loan such a vast amount of monies and then go on a spending spree and spend all that money over a period of 2.5 months. So ultimately, the state submits that the above-mentioned actions that I just mentioned show that we cannot talk of true remorse after her conviction. The court will note in Exhibit S1 S2, the correctional supervision report, page 2, on the bottom. The correctional supervision compiler of the report says, the accused told me that at the time she was still young and started to use the money because she reported the matter and nothing came about it. She told me that she regrets what she did because the reason for her regret, indicating the correctional supervision, is because she bought useless things with the money and she did nothing for her grandmother. Now this is contrary to what I heard earlier in argument that she was supporting anybody with that money. There's also another quote on page 6 of the correctional supervision report again, stating the accused regret what she has done, as she's stating that she was still young at the time. Your Worship, then I refer to the pre-sentence report, page paragraph 9.11 on page 11 of the report, stating the accused, it's in the second paragraph of paragraph 9.1, the accused verbalizes remorse and guilty state of mind. She said during spending she did not realize the wrongfulness of her actions, but now she understands what she has done wrongly. She said she regrets what she did. This can be used, the state's submission is, it's clear, if you are ultimately convicted, you are in big trouble, especially on a big amount like this. My submission is that the regret that is being referred to in the pre-sentence report is the regret because she knows that she's in deep trouble today. And it has got nothing to do with true remorse in the true sense of the word. Then I go to the bottom of paragraph 4 of my heads, closely related to the issue of remorse. The state submits is also the fact that as a result, it's clear, if there cannot be true remorse, it is clear that you did not show any real insight in the offence as such. It's clear, according to responses to the probation officer, correctional officer, that she still does not really understand what exactly did she do wrong. Page 2 of the report says she regrets because she bought useless things. That's not true remorse, and that doesn't show any insight into the offences at all. There's no mention in any of the reports that she says, I regret that I committed the crime of theft, that I stole from the complainants, or that I stole the public money. Not that I stole. We should then, the pre-sentence report was not completely subjective as well, because the state fully supports what has been indicated by the drafter of the report, Mrs. Buza, in paragraphs 10.1, 10.2 and 20, especially 10.3 of the report. If I can just quickly highlight what is in paragraph 10.1 of the report, that's on page number 12. It's indicated that at the time of the commission of the offence, she was 27 years old. She was at the age at which she is presumed to have cognitive ability and maturity to distinguish between right and wrong, and to understand the consequences of her actions. It is the view of the probation officer that theft should not be condoned. People who that these kind of crimes need to be taught a lesson by imposing harsh punishments. Theft is the taking of another person's property or services without that person's permission and consent with the intent to deprive the rightful owner of it. Paragraph number 10.2, I'll just read the last bit. Furthermore, she made use of the money for the purposes that was not intended for. Throughout this process, she was well aware of the consequences. She can be seen in the way this can be seen in the way she spent the monies. And she refers then to Annex 1, and that is basically the earlier paragraph that I referred to earlier in my argument. Even to the extent that she led a lavish lifestyle through the money. Paragraph 10.3 indicates the offence might have deprived other students to be assisted financially. Students coming from disadvantaged background like her. At the time of spending it here, she was only thinking about herself and even forgot that she was a student and needed the money for the duration of her studies. There is no excuse for spending the money that is not yours, especially knowing fully well that a mistake has occurred. You were not supposed to receive the money in the first place. It is the view of the probation officer that the fact that the accused is coming from a disadvantaged background and the positive picture painted about her does not justify or lessen the crime she has committed. The victim deserves justice. Now, I submit that in the light of the remarks that the probation officers made regarding the seriousness of the offence, it is for the state hard to understand why the pre-sentence report made as a final recommendation that the accused be considered for a suspended sentence with conditions in terms of 297 of the Criminal Procedure Act. And I refer to the recommendation on its paragraph number 12 on page 16 of the pre-sentence report. I would like to highlight just a few further guidelines that the state would like to indicate what would be a suitable sentence under the circumstances. Or before I get to that, let's first evaluate whether the accused herself is a candidate for either direct imprisonment or correctional supervision. Now, with reference, if I refer to paragraph 8.1 of the pre-sentence report, that is now with reference to the situation of the children. Paragraph 8.1, the second paragraph, indicates it came to light during investigation that the accused children were not aware of their mother's circumstances, i.e. having a pending case against her. They were not even aware of this. That shows as much of what a close bond she has with the children. Basically contradict the submissions, or is an indication contrary to the fact that the bond was that close. The family, she states further, the family managed to prepare the children about any possible outcome in the court case. The accused children will be assisted with alternative care should their circumstances are in need of care and protection in accordance to Section 50 of the Children's Act. So, by reading this, my state submission is that there is nothing, that the children is no reason to make a statement to say that the accused is not a candidate for direct imprisonment. the state would like to highlight, and that is, if the court look at the attached bundle that I've handed in on page 6, this is just a newspaper article that the state came across last week. It is a case reported in Rustenburg, where a 46-year-old man was sentenced to 6 years imprisonment for tenor fraud, and the facts are the following. About a few paragraphs down, there was a plea agreement that the court will note, and then it states there in the middle of the page, subsequent to the services being rendered, the accused collected a check of approximately 689,000 for his portion of the work. A day later, an amount of 1.2 million was mistakenly deposited into his bank account by the municipality. So we're talking about an erroneous payment. It's stated then the erroneous payment was noticed by the municipality, and the accused was contacted to return the funds. He, however, confessed to having used a portion of the money and later made a payment of approximately 689,000 with an outstanding balance of 580,000. Ultimately, here's an overpayment, 1.2 million. The accused was involved in an overpayment of 14 million, and ultimately even blew more than what this person blew, and this person got 6 years. So the court, my submission is just this could be a further guideline for the court. All cases are weighed up differently, but this is how serious the courts take these type of overpayments. They take it in a very, very serious light. Then, a second guideline is, the court will note in the charge sheet, if I can just get my, court will just bear with me. On the last page of the charge sheet, page number 4, where the exact offence is now set out. The accused was warned in terms of section 51(2) of the Criminal Procedure Act, Criminal Law Amendment Act, and we know it's called the Minimum Sentences Act. Now the question is the Minimum Sentences Act indeed applicable under the circumstances? And on page number 6 of my heads, I am trying to argue that it was indeed the case. I state there, the evidence indicated that the accused checked the balance approximately 12 times on the Thursday after notice the overpayment and started to spend the money immediately. My submission is this clearly shows that the accused from the very beginning had the intention and shown entitlement to basically the full amount that was paid into her account, and that was 14 million rand. It is clear the accused immediately had the intention to the total amount, and well knew that she was not, well knowing that she was not entitled to, and the only time that this spending spree stopped was when the account was blocked. That shows the intention. Then the accused had no intention to even stop closely, and when one look at the big amounts over such a period of time, the state submits it is that the minimum sentence under the circumstances are indeed applicable. The accused can actually, according to if I look at the facts, the court can be lucky that she was not charged for the full, that she did not claim entitlement, or that she was not prosecuted for the full 14 million rand. Because that is the intention that one can read from the facts that she entitled herself to. Had the account not been blocked, the intention, there's no indication that she would have stopped with that lavish spending spree. Your Worship, then I don't want to bore the court then with further case law. Basically, the further case law was basically just supporting the state's argument, and that these type of aggravating factors that I have highlighted. Most important is the first case. It's a Grahamstown Eastern Cape High Court decision, that Janet Riley case, indicating, and I have summarized which paragraphs the court can look into. It's indicating, for instance, except if the court so decides that the minimum sentence is applicable under circumstances, it specifically says the court has a very wide discretion on sentence. But if this minimum sentence comes into effect, the courts, with respect, hands are tied much more to a high degree, because it has been stated. I would like to hand in just a brief summary. I think I've already handed it in as part of the bundle. I made a brief summary of the case law surrounding minimum sentences. Is there something like that handed in already? Yes. And the court will see. It's been repeated all along. Must not pay lip service to the minimum sentences act. Paragraph D on the next page, are not departed from lightly and for flimsy reasons. The court can look at paragraph J. In doing so, account must be taken of the fact that the crime, particular crime, was singled out for severe punishment if the benchmark of 500,000 has been exceeded. And the sentence imposed in lieu of prescription should be assessed by due regard to the benchmark that the legislator provided. The legislator provided the sentence already. 15 years is supposed to be. So, Your Worship, I fully understand that the court needs all its mercy it can give to the accused to keep her out of prison. But, Your Worship, under the circumstances, state submission is, if one look at all the aggravating factors, I don't see the reason how the court is going to be able to depart from that. And ultimately, therefore, it is the state submission. I also refer to a few other cases, Lang, Tsipo, and some others. The state submission ultimately is that direct imprisonment should be the suitable sentence, unfortunately, under the circumstances. The public, the community at large, want to see it's their public money that has been stolen. 800 and something thousand rand of it. They would like to see justice being done. They want to see that the courts take this in a very serious light. Students, for deterrence, students must know if they try their luck, so to speak, on credit cards using the university's money, the courts will come down very harshly. So my submission is, unfortunately, one needs to set an example under the current circumstances, and my submission is therefore that ultimately direct imprisonment is the only suitable sentence under the circumstances. Thank you, Bishop.
Briefly, so, Your Worship. It reads as follows. A learning in this scenario is that systems from IntelliMali also need to be reviewed so as to be able to detect and prevent similar occurrences. Erroneous transactions with immediate effect. That is why Worship, I submitted Worship that to my own observation, the report Worship was thoroughly compiled. Now, as it suggests Worship that the stage was set for the 26-year-old to commit an offense, I will not take it any further than that. However, Your Worship, my emphasis will be that the accused was a 26-year-old student at the time. You should be state, if I may, once again, you should go back to the trial. The state spent quite a considerable amount of time trying to place and explain the relationship between NSFAS, Walter Sisulu University, and IntelliMali in terms of trying to explain the issue of the public funds worship. If you recall, worship, the state spent quite a considerable time on that aspect. But worship, what now, since indeed these are public funds, however, worship, the community, interests of the community are represented in this scenario by, we'll say, worship, by NSFAS. Now, worship, I wish to draw your attention once again to the submissions placed before you through the report of what NSFAS has said about this entire matter. Worship, the state worship submits before you that the accused didn't collaborate. Now, seemingly, worship, how the state now has placed it before you, seemingly they, in a way, construe this as a denial of liability. Worship, again, if I may refer you to page 11 of the report that was compiled by the probation officer. Worship, she states the following. According to court records, the accused pleaded not guilty to the offense. However, during the interview, she said the court has addressed her about all the factors surrounding charge of theft, and she understood and acknowledged charges against her. Worship, this is not one of the straightforward theft cases. I think that has been placed before. How I wish my learned friend had gone through the judgment that this court has presented. That will be very clear from my learned friend that this was not one of your ordinary theft cases. And therefore, Your Worship, this may not be construed as lack of remorse on the part of the accused. Worship, the issue of children. You cannot imagine a parent who would call a very young child 13 years and 10 years old and tell them what has transpired in the past 4 years. I mean, that would really, I don't even know how to put it. But worship, the protective mother who cares for her children will do what the accused has done and shield and protect
Mr. Pakade and Advocate Salia. Just before resumption before the address by the state, we had a discussion in chambers, so may I just assume and place on record that it was discussed and arranged amongst parties that sentence should stand down until tomorrow. Is that still the position? Miss Money, as you can imagine, both reports are lengthy reports. It contains a lot of information. It contains a lot of factual information that the court needs to consider. The court further needs to consider, or is obliged to consider, the address by Mr. Pakade in this regard and the address by Advocate Salia in this regard. Therefore, the matter is called for until tomorrow, March 8:30, bail is again extended and warrant extended. Thank you. For now, may I just ask, we will continue with the other matter shortly. I will adjourn so that you may all just have an opportunity to remove or do whatever you need to do. Then I'll adjourn at this point. addressed by Advocate Celia in this regard. Therefore, the matter postponed for sentence until tomorrow, that is 30 March, 8:30, Regional Court 5. Bail is again extended and therefore warned 8:30. Thank you. For now, may I just ask, we will continue with the other matter shortly. I will adjourn so that you may all just have an opportunity to remove and do whatever you need to do. Then I'll adjourn at this point.
All right, court of fire.
It's all good.